Greetings, this is Michael Swain, the Executive Director of Freedom of Religion South Africa. And we are here today to talk through a very, very important bill that is currently before the National Council of Provinces and doing the rounds, going through the different provinces with public participation hearings open. And we're speaking this morning, of course, about the Expropriation Bill. And our attorney, 4SA's attorney, Mrs. Liesl Pretorius, has been in the Western Cape parliamentary hearings and making submissions on this. And we are now going to have a discussion to really unpack this in a little more detail, because this is a very important and very controversial piece of draft legislation with potentially very adverse consequences that will potentially very adversely affect our right to religious freedom. And of course, the question remains, because expropriation means taking something away and potentially not paying a single rand for it. What happens if, for example, the land on which a church or mosque or synagogue or temple is earmarked for expropriation? So without more ado, thank you, Liesl, for being part of our conversation today. And thank you for all the great work that you've been doing. And maybe you could just start off by telling us, why is the expropriation, in fact, a threat to religious freedom?
Yes, thank you, Michael, and viewers. Well, the Expropriation Bill, as you said, firstly, it will not only make it possible to expropriate land, but also to expropriate it without compensation, 0 rands to be paid to this owner who has just lost their land. And we know that many faith communities own and use property for religious purpose. So if the Expropriation Bill becomes law, in its current form, as it is currently written, these faith communities could potentially see their property expropriated against their will and for no compensation, which obviously has a financial implication as well. Now, at 4SA, we're very aware, and we want the public, you also need to know that the Constitution protects your fundamental right to religious freedom of both individuals and of religious communities. And that includes your right to practice your faith in community as with others, or in association with others, as the Constitution puts it. So, for example, if a particular religious community loses the piece of land where they gather to worship, to fellowship, that community's ability to exercise their faith, to enjoy their right to religious freedom in community, in a communal setting, will be seriously undermined, seriously disrupted, and even to a great extent, even be made impossible. So this is why, from a religious freedom point of view, 4SA is arguing that property used for religious purposes and owned by religious institutions, associations, should not be expropriated at all.
So maybe then you could just unpack some of the challenges, and what are we particularly recommending should be done to protect religious communities from potentially losing their property and therefore their right to worship, for example, from this expropriation bill?
Well, the first thing that we need to look at, Michael, is the problematic aspects of the expropriation bill. A major problem that immediately pops up is the definition of property, because only property will be expropriated. But the definition of property is too wide. It is currently linked to the definition of property in the Constitution, and the constitutional protection of property is much wider than land. So that's the problem. Currently, property is not limited to land, and that makes it overbroad. So what is property if it's broader than land? It could include vehicles, equipment, furniture, kitchenware, books, tools, linen, even clothing, things that many religious communities own and use. So in the context of expropriation, this can lead to some very bad and even absurd consequences. So we're saying if property rights are threatened, then obviously the property owned by religious communities are threatened, but we need to tighten it so that it actually makes sense in the context of expropriation at the very least. So in our submissions to Parliament, we recommended that the definition of property must be restricted, limited to land only, and appropriate land-related property rights.
Yeah, and maybe I could just jump in there and say, can you see in this bill where there would ever be a justification for property that is owned by a religious community to be expropriated? Well, what would the rationale that they would use be, and why do we think that that is inadequate in the current drafting of this bill?
Well, in the current draft, there is no exemption for religious property or property owned by religious institutions. So there's a potential that it can be expropriated. It doesn't have a clause that specifically protects it. And when you look at the clauses in the bill that deal with expropriation, and also very specifically expropriation without compensation, it lists various circumstances under which property can be expropriated. But here's the problem. It's worded in this way. Property can be expropriated in these circumstances, but it's including, but not limited to. So legally speaking, that is an open list. That means when we look at this bill, we cannot at this moment say, these are all the circumstances under which property can be expropriated. And that's very difficult then to judge or to consider whether we want this bill or not. So that's the open list is problematic. And it refers to all relevant circumstances. And these are not defined. So we don't know what we're talking about. And yes, the bill has a definition of public interest. The bill says property, one of the requirements to have property expropriated is that it must be in the public interest. But the definition of public interest is also quite a wide and vague definition. And that's again problematic from a legal perspective. We need laws that are clear, that we understand this is what it means, and it's limited to these circumstances, not wide definitions. That's open to abuse. So specifically with regard to the definition of public interest, our recommendation was, well, South Africa has certain international law obligations that are binding on the Republic. We refer specifically to the African Charter on Human and People's Rights. That relates to various topics, but including land reform. And in connection with land reform, the Charter says land reform must meet a public need. So we said, take that definition of public interest and include in that definition that land reform must meet a public need. So that tightens the circumstances to ensure that property is not expropriated in ways when it wouldn't meet a public need or where it isn't in the public interest. And speaking of the public interest, we are aware that the faith communities of South Africa do incredible good work for the public, for their fellow man. They feed the poor, they clothe those are destitute, provide shelter, visit the sick and the elderly. If they are disrupted because their property is taken away, their base from which they fellowship and they serve others, how can this ever be in the public interest? And if somebody says, well, that wouldn't be the intention of the bill, we say, that's good and fine, but there's no problem. There wouldn't be any mischief if you can't put that very clearly into a bill. Make it clear that religious property is protected so that somebody somewhere down the line doesn't think that, okay, there's an opportunity here to expropriate property that is owned by religious institutions.
Yeah, I think that's a very important point you've raised, because we never attribute bad intentions to government when government are trying to draft legislation or whatever they're doing. We assume that they're doing it with the best interests of the people at heart because they are the democratically elected representatives of the people. But the other thing that, of course, we have seen in many instances is that once a law is passed, unless it's properly drafted, unless it's clear, unless things are, if you like, catered for that need to be catered for, once it's in place, it is in force and enforceable. And we have what we call the law of unintended consequences, where, of course, sometimes laws are then used for purposes for which they were never really originally intended. And yet now you're faced with the fact that it is the law, and what can you then do about it? And it's often very difficult to then reverse that law. It takes another whole process. And of course, in the meantime, you can suffer deeply adverse consequences. So, well, I think to just emphasize the point, our interest in this matter is purely to protect the right to religious freedom, which of course is the right of religious organizations to own the property that they have and are using for their purposes. But tell us about the other element of it, Liesl, because obviously it's talking here about expropriation without compensation. And this has been probably one of the most controversial elements of this bill. So maybe you can just unpack that a little bit for us and why we believe that this is something which also needs to be addressed.
Yes, as you say, Michael, a very controversial aspect of the bill. Our issue with expropriation without compensation, something that the bill intends to provide for, is that arguably it is unconstitutional. Section 25 of the Constitution specifically deals with property rights. It's called the Property Clause. And in section 25, it specifically says that a payment for property, compensation for property, must be just and equitable. Now, the problem is that this bill says it also refers to payment must be just and equitable, but it goes on to say that under certain circumstances, just and equitable payment could be null compensation. Null compensation is another way of saying no compensation, without compensation, 0 rands. And that to us is problematic because there's uncertainty about whether null compensation can ever be just and equitable as contemplated and required by the Constitution. A little over a year and a half ago, Parliament rejected a bill that was aimed at amending Section 25 of the Constitution, the property clause. It's called the Constitution 18th Amendment Bill. And Parliament rejected that bill. So the property clause in the Constitution stands as is. And this bill is what we call subsidiary legislation. That means it is second to the Constitution. It must align with the Constitution. This bill cannot allow for anything that the Constitution does not allow. So if the Constitution does not allow expropriation with a compensation, this bill cannot circumvent that. It will immediately be open to a constitutional challenge. So for that reason, one of our recommendations to Parliament is, as you say, we want to come alongside. We assume that there's good intentions. We don't want unintended negative consequences. So we said, Parliament, we recommend that you approach the Constitutional Court, you get a declaratory order, which will set out and address specifically this issue about whether null compensation can ever be just and equitable compensation as required by the Constitution. Because if you don't do that, it basically is you're putting the cart before the horse.
Yeah.
So we were, and on a little side note, we were quite surprised. It was during the public hearings in the Western Cape Provincial Parliament, where an official from the National Department of Public Works and Infrastructure, the department who's the custodian of this bill, said that null compensation is different than expropriation without compensation. But that makes no logical sense because he said, you know, with null compensation, there is a list of criteria that needs to be considered and processes followed. But the bottom line is whether a process is followed and criteria are considered, if at the end you get no compensation, you get null compensation, you're without your land and you're not getting any money for it. The result is the same. So we think that's a very important issue to address, this issue about the constitutionality of expropriation without compensation. You know, is it constitutional at all? And our recommendation was remove those provisions until you have clarity.
Yeah, no, so it's like, what's the difference between 0 and 0? You know, like
exactly.
Not a lot.
Not in the real world.
So the other question, I think, because people will be wondering, well, what about the law courts? I mean, can literally government come in and say, we're going to take away this land? I mean, do you have any form of redress? Can you go to the courts, for example? And what is our view on the bill's provision for judicial oversight?
Well, Michael, our view when it comes to judicial oversight, the bill provides for judicial oversight in most, but not all matters where there's urgent expropriation. And our recommendation there was, why only cater for some instances where property is expropriated on an urgent basis? And it's important to note, when your property is expropriated on an urgent basis, it can be expropriated for up to 18 months. And yes, the bill says you must be paid just and equitable compensation. But as we know, the bill also says no compensation is potentially just and equitable. So you can be without your property for up to 18 months, receive no money for it.
Wow.
If it's specifically in the instance where there's a state of disaster. And this is the instance where the bill does not allow for judicial oversight. So our recommendation was no urgent expropriation of property without judicial oversight. If a matter is truly urgent, approach a court for an urgent court order. So at least the issues are ventilated and that there are no abuses and violations of fundamental rights.
Right. And that's obviously I think, fair and reasonable, and we're pushing for that very strongly. The other question which came up the other day, which I thought was quite an interesting one, was that some churches who don't have land are actually thinking that this potentially is a good law because it will give them the opportunity to access land that they don't have. And the secondary element that is also on that, but perhaps slightly different, is of course that some churches are meeting and have been meeting regularly and consistently on land that they do not own. They've effectively been setting up, for example, tents on a Sunday on a piece of public land or whatever. What about those two scenarios? The first scenario being, I haven't got land, but I'm going to use this bill to get it potentially. Can I? And the second is, well, what if I'm using public land that I don't own and I've used that historically and our community's been meeting there on a regular basis? Maybe you could just touch on those two issues.
Well, as to the first scenario, the expropriation bill is not a way to acquire property. It is something that will be used by government. So as a private citizen or as a church or a community, you cannot approach government on the basis of this bill and say, we don't have land. We've been using this land. We would like this land. Please expropriate it for us. When I attended the Western Cape Provincial Parliament's public hearings, the official from the National Department of Public Works and Infrastructure made that very clear. This is not a way to appropriate land if you don't have land. As to the second scenario, people meeting regularly, somebody else's land, they don't own that property. Like I said, our suggestion was to write in a special exemption clause into the bill that exempts property owned by religious institutions and or used for religious purposes, basically property that is used in connection with the exercise of the constitutional right to religious freedom and the rights of religious communities, exempt that from expropriation. Our intention with that exemption is that this will also protect those people who are meeting on a piece of land and regularly do so that they don't own. Now, the owner of the land might have other recourse to them, but we would argue that at least they are an interested party, and if they have nowhere else to go, it would arguably not also be in the public interest to expropriate that property, because then they wouldn't have anywhere else to go. So hopefully it would provide some protection to such people as well, so that they can continue to exercise their communal rights to religious freedom, obviously subject to other laws and regulations that are in place in that area. So Liesl, just as we bring this to a wrap, now we've had obviously the provincial hearings, what is the next phase and stage? What is 4SA going to be doing about this, and how do we see this playing out? Well, Michael, as the provincial hearings are wrapping up in the 9 provinces, the next step would be for the National Council of Provinces to host their own public hearings, because we've already sent in our written submissions to the National Council of Provinces, and we've specifically asked for opportunity. If they host public hearings, we want to address them as well. So that would be the next step. If the National Council of Provinces accepts this bill as is, they don't amend it, they pass it as is, it will go to the president to be signed into law. But obviously what we are contending for is that the bill will be amended, and if there are amendments, we'll get sent back to the first House of Parliament, the National Assembly, to have a look at it again. But those are the next steps going forward.
Wonderful. And obviously, we 4SA are keeping a very close eye on this. We have done from the beginning, because as we said, sometimes there are unintended consequences from legislation, and the unintended consequences of this piece of legislation could be deeply detrimental to the faith communities of this country. So we will certainly be following that, and we would urge you to follow us. Go to the forsa.org.za website. We always have the latest news there. We have our Facebook page, Freedom of Religion SA. We have, of course, this YouTube channel, and we want to encourage you to join us. Please consider supporting us, donating to us. We are only able to do this work that we do because of the voluntary financial contributions that we receive. So we really want to encourage you to click that important donate button. But until the next time, Liesl, thank you so much for all the work that you do. You are an incredible asset, and we really want to thank you for representing in the fight for faith and freedom, the faith communities in these different forums.
Thank you, Michael. It's only a pleasure.
Until the next time, thank you so much.
Good day. This is Daniela Ellerbeck, the Legal Advisor to Freedom of Religion South Africa. Remember to like and share this video, and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.